get more reaction, we're joined by Legal Resources Center attorney Wilmien Wicomb. Thank you very much, Wilmien, for joining us this evening. What have you made of the day's developments on this issue?
Well, it was quite an extraordinary judgment, and so we're, of course, very, very excited, as Nonclair's also communicated. This was an interim interdict. It stops Shell from going ahead with the survey at the moment. Next step will be to argue a final interdict, which raises the legal issue whether Shell must first conduct an environmental impact authorization before they can do exploration at all. And that will happen in the new year, and until then, Shell cannot continue with the survey. I think it is hugely significant for many reasons, but one of them certainly that Shell's argument to the court was very much about the financial beating that they will take should the interdict be granted. And also, they were arguing about the economic impact that the survey, prospecting, and whatever may follow will have on the economy. And we often see those kinds of economic considerations outweigh the rights of local communities, but not today. The judge was very firm in saying that, Shell chose to ignore the constitutionally protected customary rights of these fishing communities and chose to go ahead without speaking to them. And it doesn't matter how much money they're going to lose, they must be stopped.
One wonders how many more of these cases are out there, right, with multinationals coming in and disturbing areas that go unreported. But I'd like to expand on an issue you touched on. So the applicants may also challenge the awarding of the exploration right based on the failed consultation. Please expand on that for us.
Yes, so this application was really based on a legal argument, and it had to do with the difference between the regime under the minerals legislation, and then it changed after 2013 when Shell was awarded the right in our new environmental legislation. But in the course of the proceedings, it became so abundantly clear that Shell absolutely failed in consulting with these communities that will be most directly affected. And certainly the applicants raised in court that they think that is a basis for challenging the very awarding of the exploration right. So not even the question of whether an EIA is necessary, but simply on the basis of the fact that these communities were ignored. The exploration right itself may well have to be set aside.
And where does government come in here? Because they gave them that right, no?
They did, yes. So that kind of review, setting aside the exploration right, will be a case against the minister, and a case to say that the minister's decision must be thrown out, and the exploration right thrown out with it.
Thank you very much for helping us make sense of that. Wilmien Wicomb is attorney at the Legal Resources Center.